but I always say the art of being a progressive is that your second argument has to be the opposite of your first argument. When Arizona passed SB 1070, all of these left-wing legal scholars said the state has no authority to have a different standard on immigration than the federal government, and the president has signed DACA, and there's nothing you can do about it. Now, the fact that Article 2 does not provide the federal executive from the authority to sign something like DACA was irrelevant. They said states cannot have their own immigration policies. Now they're saying states can have their own immigration policies.
They want to have it both ways. And it just doesn't work. It's called preemption. When the federal government has the authority and decides to take over an area of the law, then any state law to the contrary or differing to it is null and void. It goes back to the supremacy clause. The U.S. Constitution is the supreme law of the land. California, Texas, any other border state, even a non-border state with an international airport, they cannot set up their own immigration rules. And if they try to do so and they're in contravention of federal law trumps every time. Any first-year law student with a D- grade point average, I think, can figure that one out.
Now, wait a second. If California could say let them all in, could Oklahoma say throw them all in jail for 10 years or more?
The states cannot set their own sanctions, if you will, criminal sanctions for illegal entry. That's the province.
Oh, okay. I know that Article 1, Section 9 expired state powers in immigration in 1808, which is 1808. So no state has had that power. But if California is going to assert that it can do as it pleases, does that mean the other 49 states can have their own penalties, like upwards of a decade of incarceration?
No, the individual states cannot legislate.
No, I was just a thought exercise. That
yeah,
okay, well, if you want to play that game. Now, here's the other side of this accusation, and I noticed this, that when liberals write about the Constitution, one of two things happens. Either their basic assumption is that the Constitution mirrors their own view of fraternity or equality or civil rights, even though the Bill of Rights is civil rights, or they seem to think penumbra is the rule of law. So now they're talking about, well, we don't have any religious tests. Well, I'll read it to you from Article 6. But no religious test shall ever be required as a qualification to any public office or public trust under the United States. That has nothing to do with people in Yemen.
No, people in Yemen are people in Yemen. It doesn't matter what religion they are people in Yemen. It's not a religious issue. It's a where they are.
But no,
type of
but
issue.
wait, we could say we're not letting any more pick the religion. We're not letting any more Buddhists into the country. The religious test is for public office of the United States, having nothing to do with immigration. To view it that way would be a penumbra.
Oh, you hit the nail on the head. An alien who is not inside the United States has zero, no constitutional rights in the United States, not to enter, not for any other purpose. The only type of person who has any kind of constitutional rights outside of the borders of the U.S., guess what? This is going to be a shocker. It's United States citizens. Even permanent residents don't have the constitutional rights in that sense. Now, they do have some statutory due process rights. If they are denied entry, they get to have a hearing and this, that, and the other. But that's not a constitutional issue. That's granted to them by statute. And so to the extent there's an overlay between statutory law and constitutional law, fine. But there is no constitutional right for any alien to enter the United States, period.
Now, where does this go from here? So is this the Ninth Circuit Court? Where does this go? Oh, U.S. District Court in San Francisco. Where does this go from here? Because it would even be hard for the Kagan, Sotomayor, Ginsburg wing. I mean, shouldn't Democrats be fearful of a question of the 10th Amendment with money attached to it going to the Supreme Court? Because wouldn't that call into question, well, where's the federal authority to impose Medicare or Medicaid or Social Security on the states? None of these are mentioned as powers of the federal government, and all powers not delegated to the government of the United States are reserved to the states or to the people. That's the 10th Amendment. I mean, could this open up for lack of a better phrase, a Pandora's box of cases on if they want to pick a fight over the 10th Amendment and city-based or state-based funding, that we can ask a lot of questions about money that's going around the country.
And I'm happy with the debate about the 10th Amendment. I'm a big fan of the 10th Amendment, and quite frankly, I think a lot more power needs to flow back to the states. And in that regard, you're exactly correct. Some states might, it's like the dog that's trying to catch the car, chasing the car down the street. If you catch it, you might not really want it once you catch it. But speaking of power flowing back to the states, here's an idea, and they're looking at this in Texas with regard to sanctuary jurisdictions, okay? They're talking about in the state legislature making it possible for the state to remove from office any sheriff who does not honor immigration detainers. How about that for power going back to the states and saying to its local officials, you will follow federal law. As a matter of state law, we're going to require you to honor immigration law as it is spelled out by Congress. That's another idea. How about let states have some power to rein in its own officials? There's 33, I think, Republican governors in the United States, and I don't know how many legislatures, but there is certainly enough states out there that if the states wanted to take some action to put a stop to this, they could do it. Congress could also make it a crime for a local official not to honor an immigration detainer.
Well, didn't the federal government, the Department of Justice, came down pretty hard on a county clerk in Kentucky that refused to issue a same-sex marriage license after the same-sex marriage ruling in the Supreme Court? They went after her.
They did go after her because the Supreme Court determined that as a matter of federal constitutional law, she had an obligation to do so, and that if she refused to do it, they were going to, potentially send in, who knows, the federal marshals. Sort of like happened back in the civil rights era. You had the federal courts sending in the marshals to enforce civil rights rulings. So,
wait, does that mean potentially a mayor or governor? Does that mean if Jerry Brown, and we're going to run out of time here, we got less than a minute, if Jerry Brown really mounts a sanctuary state fight with the Trump administration, could the U.S. Marshals remove him from office?
I think that if that situation were to go that far and the courts were to weigh in on a national level with maybe a Supreme Court ruling, the Supreme Court can enforce its rulings by use of force, and the federal government could do it. I hope it doesn't come to that, but it's not beyond the realm of possibility.
I got to be honest with you, watching a blue state governor be perp walked out by U.S. Marshals for violating federal law would be pretty entertaining.
That would be great television and maybe great radio, too.
All right, I got to leave it there. Phil Holloway, former police officer, lawyer, and legal analyst, moving from network to network. We'll speak to you next time.
Great. Thanks. Have a good one.